You're watching the Bloomberg Law Bankruptcy Review. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to check out his daily bankruptcy column, available on BloombergLaw.com. It's also on the Bloomberg Terminal. Two items to go through today, and first one is the ResCap situation, Residential Capital. It's been in our podcast quite a bit as of late, and lo and behold, we have a new examiner appointed to the case. Bill, what's happening here?
Well, I tell you what I hope happens, and that is I hope it goes as well as Dynegy did. ResCap and Dynegy are probably two of the messiest cases we will have seen in like 5 years. Mm-hmm. And compared to some of the other messy cases like Tribune and WAMU, Dynegy went down like a hot knife through butter. Mm-hmm. And the answer is why? Well, because bankruptcy judge Cecilia Morris, in her first huge case, decided right at the outset there should be an examiner. So she brought in an examiner, and lo and behold, he came down with a terrific report pretty quickly. From that, the examiner became a mediator, whacked both sides upside the head, and in record time, frankly, for a big case, came down with a deal. In the ResCap case, we know that there will be an examiner because that's what the bankruptcy judge said. We don't yet know who the examiner is. The U.S. trustee has to select it. We also don't know exactly what kind of a portfolio the judge is going to give to the examiner for ResCap. It could be extremely limited, theoretically, if the bankruptcy judge decides that it is best for the creditors committee to carry the laboring oar in this investigation. Problem is this, however. I have no doubt the creditors committee could do just as fine a job investigating, perhaps even better. Problem is this. The investigation is only half of it. After the report comes in, then you have to bash everybody about the head and ears to try to get agreement on a consensual plan. That's where an examiner is much better, because an examiner is not beholden to anybody, does not have any constituency. The creditors committee, however, do have a constituency. So when they go into negotiations, people can discount their opinions just saying, hey, shoot, they have an axe to grind. They're just trying to help the unsecureds. They can't look at this whole situation objectively, but that is what an examiner can do. And that was a brilliant thing about what Judge Morris did. She carried the examiner over, and he proceeded to have, I think it was something like 50 mediation sessions in, frankly, just a very few weeks, and brought everybody together. Ergo, I am crossing my fingers, hoping that pretty much the same thing happens with ResCap. If it does, it is another home run for the good old Southern District of New York. Let's hope the Yankees play that well this year.
Right on. Yeah, it'd be nice to see a quick resolution in what looks like a pretty tough case. Too bad we can't say the same about Vitro. We've seen a lot of developments. The case has just been absolutely fascinating. The Mexican glassmaker that has bankruptcy proceedings in Mexico and the United States. A very important case for cross-border insolvencies. At this point, Bill, are we starting to get some clarity, at least, as to how this entire situation is going to get resolved?
Well, I think we're just starting to. You know, Vitro reminds me, down home we used to say, if you want to get attention from a mule, you hit him upside the head with a 2x4. Mm-hmm. And that, I am sad to say, is what bankruptcy judge Harlan Cooter Hale in Dallas did. He hit him upside the head with a 2x4. Judge Hale said that the reorganization plan, which they got approved by a court in Mexico, would not be enforced to any extent at all in the United States. The reason for that is because only the Vitro parent, which does not have a single peso of income, was in bankruptcy. The subsidiaries have all of the assets, all of the income. They were not in bankruptcy. But this plan relieved the subsidiaries of their debt, chopped it down rather substantially, and Cooter Hale said, you can't do that under U.S. law, and I'm not going to let you do it by importing it from Mexico. So this was a major loss for Vitro. They are, of course, already appealing to the U.S. Court of Appeals in New Orleans. It remains to be seen whether they will prevail or not. But in any event, right now, this is a terrific setback for the Mexican company. It is a huge win. I mean, enormous win for U.S. bondholders. It gives them some, I guess you might say, assurance that when bonds are sold through the U.S. markets, some degree of our notion of fairness is going to be overlaid in deciding whether or not to enforce a foreign reorganization plan. This, I think, Lee, depending upon what the Court of Appeals tells us eventually, is going to go down in history, at least so long as we've had cross-border law, as the most important multinational bankruptcy in the history of U.S. courts.
All right, well, there you have it. We have Judge Cooter Hale metaphorically swinging a 2x4 at a mule. Good stuff. We're going to leave it there for now. If you'd like to learn more about the cases and issues we just discussed, be sure to check out Bill's column. It's available on BloombergLaw.com and also on the Bloomberg Terminal. You can follow our updates on Twitter and see our updated videos on YouTube. I'm Lee Pacchia. Thanks for watching.